Hello friends, welcome to the Point. In today's session, let's discuss about the emergency provisions. Emergency provisions, they are contained in Part 18 of the Constitution from Articles 352 to 360. The emergency provisions, it enables the central government to meet any abnormal situations in our country. And the rationality behind the incorporation of this emergency provision in the Constitution, it is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system and the Constitution. So during an emergency, the central government becomes powerful and the states go into the total control of the center. That is, the state governments comes under the central government control. So at that time, the central government converts the federal structure into an unitary system without any amendment of the Constitution. And this kind of transformation of the political system from federal during normal times to unitary during emergency, it is a unique feature of our Indian Constitution. The Constitution stipulates three types of emergencies. They are national emergency, President's rule and financial emergency. National emergency, an emergency that occurs due to the war or external aggression or an armed rebellion under Article 352, and this is popularly known as national emergency. And the Constitution employs the expression proclamation of emergency to denote an emergency of this type. President's rule, an emergency due to the failure of constitutional machinery in the states according to Article 356, and this type of emergency is popularly known as President's rule, and it is also known by other two names. One is state emergency, or it is also called as constitutional emergency, and the Constitution does not use the word emergency for this kind of situation. Financial emergency, financial emergency due to a threat to the financial stability or credit of India under Article 360 is said to be an financial emergency. Let's discuss about all the emergencies in detail. National emergency. So grounds of declaration means when a national emergency is declared. So under Article 352 of the Indian Constitution, the President, he can declare a national emergency whenever he feels that the security of India or part of India is threatened by a war or external aggression or an armed rebellion. And it may be noted that the President can declare a national emergency even before the occurrence of war or external aggression. If he is satisfied that there is an imminent danger in the country, and at that time the President can declare a national emergency. The President, he can also issue different proclamation on the grounds of war, on external aggression, armed rebellion or imminent danger, and whether there is a proclamation already issued by him and such proclamation is in operation. And this provision, it was added by 38th Amendment Act 1975. And whenever a national emergency is declared on the ground of war or external aggression, it is known as external emergency. And whenever the national emergency is declared on the ground of armed rebellion, and it is known as internal emergencies. And remember, originally our Constitution, it mentioned the internal disturbance as a third ground for the proclamation of a national emergency, but the expression was too vague and it had a wider connotation, and hence the 44th Amendment Act of 1978, it substituted the words armed rebellion for internal disturbance, and therefore it is no longer to declare a national emergency on the ground of internal disturbance, as it was done in 1975 by the Congress government, which was headed by Indira Gandhi. And how can a president proclaim a national emergency? President can proclaim a national emergency only after receiving a written recommendation from the Union Cabinet, and this means that the emergency can be declared only on the concurrence of the Cabinet and not merely on the advice of Prime Minister. So in the year 1975, the then Prime Minister Indira Gandhi advised the President to proclaim emergency without consulting her Cabinet, and the Cabinet was informed of the proclamation after it was made as a fait accompli. And the 44th Amendment Act of 1978, it introduced this safeguard to eliminate any possibility of Prime Minister alone taking the decision in case of national emergency. And in the 44th Amendment Act, it said that the President can proclaim a national emergency only after receiving a written recommendation from the Cabinet. Parliamentary approval and duration. The proclamation of emergency, it must be approved by both the houses of Parliament, that is Lok Sabha and Rajya Sabha, within 1 month from the date of its issue. And originally, the period for the approval by the Parliament, it was for 2 months, but it was reduced to 1 month by 44th Amendment Act of 1978. And if the proclamation of the emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during the period of 1 month without approving the proclamation, and then the proclamation, it survives until 30 days from the first sitting of the Lok Sabha after its reconstitution, provided the Rajya Sabha has in the meantime approved it. That means if the Rajya Sabha has approved previously, then the proclamation of emergency, it survives till 30 days from the first sitting of Lok Sabha. Once both the House of the Parliament approves the emergency, then the emergency continues for 6 months, and it can be extended to an indefinite period with an approval of the Parliament for every 6 months. And this provision for the periodical parliamentary approval, it was also added by the 44th Constitutional Amendment Act 1978. And before this 44th Amendment Act, for a periodical parliamentary approval, and the emergency, once it is approved by the Parliament, it could remain in operation as long as the executive decide. Revocation of proclamation. A proclamation of emergency, it may be revoked by the President at any time by a subsequent proclamation, and such a proclamation, it does not require parliamentary approval. And the President must revoke a proclamation if the Lok Sabha passes a resolution disapproving its continuation. Again, this safeguard, it was introduced by the 44th Constitutional Amendment Act of 1978. And before that, a proclamation could be revoked by the President on his own, and the Lok Sabha had no control in this regard. Effects of national emergency. A proclamation of emergency, it has a drastic and wide-ranging effects on the political system, and these consequences, it can be grouped into 3 categories. They are effect on center-state relation, effect on the life of the Lok Sabha and State Assembly, and the effect on the fundamental rights. Let's discuss in detail about the effects of national emergency. Effect on center-state relations. While a proclamation of emergency it is in force, the normal fabric of the center-state relation, it undergoes a fundamental change or a basic change, and and that change can be studied under three heads. They are executive, legislative and financial. During a national emergency, the executive power of the center, it extends to directing any state regarding the manner in which its executive power is to be exercised. And in normal times, the center can give executive directions to a state only on a specified matters. But during national emergency, center becomes entitled to give executive directions to any state regarding any matter, and thus the state governments, they are brought under complete control of the center, though they are not suspended. Effects of center-state relations on legislative system. During a national emergency, the parliament becomes empowered to make laws on any subject that is mentioned in the state list. And the legislative power of a state legislature, it is not suspended. It becomes a subject to overriding power of the parliament. And the normal distribution of the legislative powers between the center and states, it is suspended. And the state legislatures, they are not suspended. So we can say that the constitution becomes unitary from the federal. The laws that is made by the parliament on the subjects during a national emergency, it becomes inoperative 6 months after the emergency has ceased to operate. Effect on the center-state relations in financial matters. While a proclamation of national emergency is in operation, the President can modify the constitutional distributions of revenues between the center and the states. This means that the President can either reduce or cancel the transfer of finances from the center to the states, and such a modification, it continues till the end of financial year in which the emergency ceases to operate. And every such order of the President, it has to be laid before the houses of the parliament. Effect on the life of the Lok Sabha and the state assembly. During national emergency is in operation, the life of the Lok Sabha, it may be extended beyond its normal term. That is, its normal term is 5 years. It may be extended beyond it by a law of the parliament for 1 year at a time, or for any length of the time till the emergency continues. And this extension, it cannot continue beyond a period of 6 months after the emergency has been ceased or stopped to operate. For example, the term of the 5th Lok Sabha, that is from the year 1971 to 1977, it was extended 2 times by 1 year at a time. And similarly, the parliament, it may extend the normal tenure of the state legislative assemblies also by 1 year each time during a national emergency, and that subjects to a maximum period of 6 months after the emergency has ceased to operate. That is, the extension is same for both the central government as well as the state governments. Effect on the fundamental rights. Article 358 and 359 of the Constitution, it describes that effect of national emergency on the fundamental rights. And Article 358, it deals with the suspension of the fundamental rights that is guaranteed by Article 19, while Article 359, it deals with the suspension of other fundamental rights except that is guaranteed under Article 20 and 21. And these two provisions are suspension of fundamental rights under Article 19 and suspension of other fundamental rights. So, suspension of fundamental rights under Article 19, and according to Article 358, when a proclamation of national emergency it is made and the 6 fundamental rights under Article 19, it will be automatically suspended and no separate order for their suspension is required. And when the national emergency is in operation, the state is freed from the restrictions that is imposed under Article 19. Can say that the state can make any laws, or it can take any executive actions, or it can take away the 6 fundamental rights that is guaranteed by Article 19. The 44th Amendment Act of 1978, it restricted the scope of Article 358 in 2 ways. First, the 6 fundamental rights under Article 19, it can be suspended only when the national emergency is declared on the grounds of war or external aggression, and it cannot be suspended on the grounds of armed rebellion. And secondly, only those laws that is related to the emergencies, they are protected from being challenged and not other laws. And also the executive action taken only under such a law is protected. Suspension of other fundamental rights. Article 359 of the Constitution, it authorizes the President to suspend the right to move any court for the enforcement of the fundamental rights during national emergency. This means under Article 359, the fundamental rights are not suspended, but only their enforcement is suspended. President's rule. Let's discuss about the grounds of imposition of President's rule. Article 355 of the Constitution, it imposes a duty on the center to ensure that the government of every state is carried on in accordance with the provisions of the Constitution. And it is this duty in the performance which the center takes over the government of the state under Article 356 in case of failure of constitutional machineries in the state. And this is popularly known as President's rule. It is also known as state's emergency, or it is also called as constitutional emergency. The President's rule, it can be proclaimed under Article 356 on 2 grounds. One, it is mentioned in Article 356 itself, and other, it is mentioned in Article 365. Let's see what are those 2 grounds where the President's rule can be imposed. Under Article 356 of the Constitution, it empowers President to issue a proclamation if he is satisfied that the situation has arisen in the state government and that cannot be carried on in accordance with the provisions of the Constitution. And the President, he can act either on a report of the governor of the state or even without the governor's report. And Article 365 says that whenever the state, it fails to comply with or to give the effect to any direction from the center, and it will be lawful for the President to hold that situation it has arisen in the state government, and it cannot be carried on in accordance with the provision of the Constitution. Parliamentary approval duration. A proclamation that is imposed during a President's rule, it must be approved by both Lok Sabha as well as Rajya Sabha within 2 months from the date of its issue. And if the proclamation of the President, it is issued at a time when the Lok Sabha is being dissolved, or the dissolution of the Lok Sabha takes place during that period of 2 months without approving the proclamation, and that proclamation survives till 30 days from the first sitting of the Lok Sabha after its reconstitution. And this is applied only when Rajya Sabha approves before the Lok Sabha. And once the proclamation of emergency, it is approved by both the houses of the Parliament, and then the President's rule, it continues for 6 months, and it can be extended for a maximum period of 3 years. and with the approval of the Parliament for every 6 months. And suppose if the dissolution of the Lok Sabha takes place during the period of this 6 months without approving for the further continuation of the President's rule, and then the proclamation, it again survives for 30 days from the first sitting of the new Lok Sabha members. And for this also there is a condition that Rajya Sabha should be approved before Lok Sabha's first sitting. Consequences of President's rule. The President, he acquired certain extraordinary powers when the President rule is imposed in the state. That is, he can take up the functions of the state government and the powers that is vested in the governor or any other executive authority in the state. Second, he can declare that the powers of the state legislature, it is to be exercised by the Parliament. And third, he can take all other necessary steps, including the suspension of the constitutional provisions that is relating to any body or authority in the state. And hence, when the President rule is imposed in a state, the President, he dismisses the State Council of Ministers who are headed by Chief Minister, and the State Governor, on behalf of the President, he carries on the state administration with the help of the Chief Secretary of the state or the advisors, those who are appointed by the President. And this is the reason why a proclamation under Article 356 is popularly known as imposition of President's rule in a state. Financial emergency. Grounds of declaration of financial emergency. Article 360, it empowers the President to proclaim the financial emergency if he is satisfied that a situation has arisen due to which the financial stability or credit of India or any part of its territory is threatened. And the 38th Amendment Act of 1975, it made the satisfaction of the President in declaring a financial emergency final and conclusive, and it is not questionable in any court on any grounds. But this provision, it was deleted by the 44th Constitutional Amendment Act 1978, and this act, it implies that the satisfaction of the President, it is beyond judicial review. That is, the court can interfere in this matter. Parliamentary approval and duration. A proclamation that declares a financial emergency, it must be approved by both the Houses of Parliament within 2 months from the date of its issue. And if the proclamation of the financial emergency is issued at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha takes place during this period of 2 months without approving the proclamation, and then the proclamation will still survive if Rajya Sabha gives its approval, and the proclamation, it survives for 30 days from the first sitting of the Lok Sabha. And once it is approved by both the houses of the Parliament, the financial emergency, it continues indefinitely till it is revoked. And this implies there is no maximum period, that is, there is no maximum period that is prescribed for its operation, and repeated parliamentary approval is not required for financial emergency continuation. A resolution approves that the proclamation of the financial emergency, it can be passed either House of the Parliament, and a simple majority is enough for this proclamation. That is, the majority of the members present in the House and voting. Effects of financial emergency. The consequences of the proclamation of the financial emergency are the executive authority of the center, it extends to directing any state in India to observe a canons of financial property that are specified by the center. And any such direction, it may include a provision that requires the reduction of salaries and allowances of all or any class of person serving in the state, and the reservation of all the money bills or other financial bills for the consideration of the president after they are passed by the legislature of the state. And the president, he may issue directions for reduction of salaries, allowances of any class of the persons they are serving in the union government, and the judges of the Supreme Court and the High Court. And therefore, during the operation of financial emergency, the center acquires a full control over the states in financial matters. Criticism of the emergency provisions. Some members of the Constituent Assembly criticize the incorporation of emergency provisions in our Constitution on certain grounds, and they are the federal character of the Constitution, it will be destroyed and the union will become the powerful one, and the powers of the state and both the union and the units will entirely be concentrated in the hands of union executive, and the president, he becomes a dictator, and the final autonomy of the state, it will be nullified, and fundamental rights will become meaningless, and as a result the democratic foundations of the Constitution, it will be destroyed. And therefore, H.V. Kamath, he observed that and said, I fear that by this single chapter, that is the emergency provisions, we are seeking to lay the foundations of a totalitarian state, a police state, a state completely that is opposed to all the ideals and principles that we have held aloft during the last few decades, and a state where the rights and liberties of millions of the innocent men and women will be in continuous jeopardy, and a state where if there will be a peace, and it will be the peace of the grave and the void of the desert, and it will be a day of shame and sorrow when the president makes use of these powers having no parallel in any constitution of the democratic countries of the world. And this was the criticism, it was made by H.V. Kamath. And H.N. Kunzru, he said that the emergency financial provisions, it poses a serious threat to financial autonomy of the state. See you in the next session with some other interesting topic. Thank you.